I'm Frank Cullen. I'm the Executive Director for the Council for Innovation Promotion. And we're just delighted that today we have an opportunity to hear from the Sunwater Institute, who's done a remarkable study on patent quality in the United States. And my co-chairs, Dave Kapos and Andre Yanku, will share a few of their thoughts as former PTO directors. They're very well equipped to talk to this issue. But I just want folks to know briefly about C4IP, if you don't already know. We're a bipartisan organization. We're dedicated to supporting and advancing the IP policies that really drive our innovation economy and our creative output. We know that there's been an increased attack and lack of understanding around the benefits that the IP system provides. I think anyone who looks at the United States as the world's leading economy knows that this did not happen by accident. It happened by design. It was the genius of our founders that created an IP system that incentivizes innovation and creative output. And we have to sometimes remind policymakers about that connection between our IP system and our continued success and competitiveness. So today we're here to talk about something that's a very important component to the entire formula of success, which is our patent system and a particular aspect of that. So with that, I just want to thank the Sunwater Institute. We have a great panel to provide a briefing on the report that they prepared. So with that, it's my pleasure to introduce our co-chair, David Kapos.
Well, thank you, Frank. Good morning. Great to see a lot of friends and colleagues here this morning. Let me start by echoing Frank's thanks to the Sunwater Institute for putting this study together, and thanks to all of you for coming out. So if you work at the USPTO for any period of time, you form some views about our country's patent system. And in my case, even before that, working in industry for 26 years and managing, at the time, the world's largest patent portfolio, I had a sense about what was going on at the USPTO vis-a-vis its day job, examining, granting, and rejecting many hundreds of thousands, over time millions, of patent applications. And came to believe, came to know, and to feel in my soul that, you know, that agency does a pretty good job. It's not perfect, but then the laws aren't perfect, and they're vague, and they're changing all the time. And we're talking about making fine judgments about things like obviousness and inventive step, depending on how you refer to it, and written description and sufficiency of disclosure, and all these very technical judgment-prone things, and we're dealing with the English language. And so at the end of the day, I felt, you know, I think the agency probably does a pretty good job. So then I got in there and had an opportunity to look at it firsthand and conclude, you know what, this agency does a really good job. I don't understand why there is a narrative that's taken hold that, by and large, patent quality is poor. That the PTO is putting out low-quality patents. It just never seemed to be true. So fast forward 10 more years, and through C4IP, we had the opportunity to hire some economists, to set them loose without an agenda, to say, collect the data, study the facts, let's move away from advocacy and move to evidence instead, and tell the world what's going on. And do it in a rigorous economics-based fashion. And that's what the Sunwater Institute did. So I am super pleased at both the process that the Sunwater folks used, which was objective and fact and evidence-based, the analysis that they applied to it, which was rigorous and multifaceted, and the result, which is not uncritical, analytical, looking at the issue of patent quality from many different viewpoints, providing both an analysis that leads to conclusions as well as recommendations. So I commend the study to your reading. again, congratulate the Sunwater folks. Very much look forward to the presentation coming. And thanks again for everyone joining us this morning. With that, I'll invite Andre to come up.
Thanks, Dave, and thanks, Frank, for the kind introduction. Great to see everybody, and let me start also by thanking the Sunwater Institute for what I think is a fabulous, remarkable report. It took some time to develop. They were thorough, detailed, and thoughtful, as you will hear in their presentation, and you will imminently see if you read the report. I've always wondered what economists who are set loose look like, and this is it. They really have done a fabulous job here on a very important issue. One of the reasons Dave and I started C4IP, among others, is to correct the relentless negative and false narratives surrounding the patent system that are promulgated by a whole host of interests that are unfortunately negative and detrimental to the patent system, and as a result of that, to innovation, American innovation, and the U.S. economy. And we hear these false narratives in various forms over and over again and throughout the years. The narrative about patent trolls plaguing the system. The narrative about patent thickets and evergreening, and one pejorative term after another. But one that seems to be most prevalent is that the American economy is plagued by, quote, bad patents, with no explanation, no definition as to what bad is exactly, and no study to demonstrate that actually there is a bad patent pandemic in the United States, or that there has ever been. And we, Dave and I, having worked at the USPTO and having run the agency over different administrations, we know firsthand that it is false. And we wanted to have an actual economic study to demonstrate with data that it is indeed false. When people tell you that there are, quote, bad patents, I would first challenge them to give you the evidence and the definition as to what that means. And in the end, what we know is that purely they are lying. And unfortunately, they are lying in order to drive their own private interests, whether it's economic or other interests, that are not aligned with the interests of overall U.S. economy and the well-being of our people and our innovation system. So, because of all that, as I said, we wanted the evidence. So with that, let me turn it over to the Sunwater Institute so that they can present that evidence. Thanks, everyone.
Thank you, Andre, and thank you, Dave. And we're going to now move to the briefing portion, as Andre said. I just want to take a moment to introduce Sunwater Institute leadership. Matthew Chernovic expressed great interest, and it seemed clear from the start that this was going to be a great partnership. Matthew is going to lead today's conversation, introduce his team. The researchers have done an amazing job, as Andre and Dave have said, putting together a fact-based report that can really set the record straight on these issues. So, Matthew, thank you for all the hard work. Thank you for the hard work of your team. A very impressive group. Matthew will introduce the team and walk us through the briefing today. Just want to thank everyone again for making time to be here, but especially want to thank the Sunwater team for not only their great work on the report, but also for making time to be here to share their findings and their methodology with us. So, Matthew, thank you.
Thank you so much to the C4IP team for working with us on this project. You know, I didn't come to it with preconceived notions about what the quality of the patent system was. You know, that was kind of the question I had in my mind when we started this project. So let me talk a little bit about the agenda. First, I want to tell you what Sunwater Institute is, talk to you a little bit about the background of the project as, you know, with a little more detail, talk about the team. Then Andy will walk us through the executive summary. We'll have a moderated discussion. I'll ask my co-authors some questions, and then we'll open up to the floor after that. So first, I'd like to talk a little bit about the Sunwater Institute. Some of you may be familiar with what we do, others not. We are a nonprofit 501c3 think tank. We focus on a couple of different areas. One is rights and liberties, of which property rights and intellectual property rights is a core component. And we focus on legislatures, how to improve the legislature, in particular with a focus on the U.S. Congress. We do a few different things. We do research, which is evidenced by what we're doing today. We're presenting research. We just had some research released over the last couple weeks on how to improve the U.S. House of Representatives rules process to get legislators back into the game of legislating instead of only messaging. And we did that with the Hoover Institution. The second area is we have something called LegisOne. It's a data platform that covers the U.S. Congress. We track everything in Congress and create a set of data and tools everyone in the policy process can use to try to make the legislative process better and more effective. We also publish a number of books, and you can see we just released the Legislative Drafter's Desk Reference after 10 years of hiatus. Sandy Strokoff, who ran the Office of Ledge Counsel, is the author of that book, and we just had her book signing last week. And of course, many of you may know, Sandy was one of the key drafters on much of the IP legislation over the last 30 years. So if you don't have a copy of the Legislative Drafter's Desk Reference, I encourage you to pick one up. And if you want, I can get you a signed copy. Lastly, we have training. We do training for federal agencies, how to engage with the policy process in Congress. We actually train the Senate, the GPO, and other groups that have to engage with Congress in some way. And so Sunwater is doing a lot of things that relate to making institutions work better in the United States. And of course, intellectual property is core to what we think of as the rights and liberties component of that. So, you know, I want to talk a little bit about why this project. You know, as was mentioned by Dave and Andre, there is this notion that there are too many bad patents, and this has led to some kind of crisis. That's a thing. You know, that's an idea that's out there, and really, we just wanted to say, is that true? That's a simple question that we wanted to see if we could use data and some kind of systematic methodology to see if that were really true. But another thing that comes a little bit from my heart is, as an entrepreneur, is that debates rarely address the rejection of good patents. You know, if you have a you have an idea and you go through the patent system and you get rejected and you should have received a patent, that's kind of like the dog didn't bark problem, right? And no one talks about that in the policy debate, from what I'd seen. And I always wondered if that lack of attention was justified. So we wanted to look at that in this project as well. And so we did that. And we found some interesting novel findings. The third kind of thing out there is that when you look at the policy debate, a lot of times patent invalidation rates are used, whether through courts or whether through PTAB, et cetera. They're cited as indicators that the patent system's totally broken or whatever, because there's a certain percentage of patents don't hold up in court, et cetera. So these statistics are often used to generalize to the whole patent population. And they're used even in policy reports and by serious people who care about the patent system. And so we wanted to see, is that kind of mental leap from some invalidation rate to all patents, is that an appropriate leap to make? Is it logical? Does it hold up? So we wanted to address that in this project. And then there's also this narrative, and I have some experience with this because I used to track, as part of my entrepreneurial work, I tracked the patent system in the US and I tracked the patent system in China. And there's a narrative that US patent quality is lower than other countries. And that interested me. Is it true or not? I don't know. So could we find out whether that was really true. Is there a way that we can use the data available to make some legitimate inference there? And so these were the kind of questions that fascinated us and also, of course, fascinated C4IP. And underlying those things is the question, could a data-driven approach answer these questions? Not, a cherry-picking an idea here or there. Looking at the data in a systematic way across many different areas, can we actually learn anything from the data? Can it tell us something to answer these questions? So that's really what, is behind this project. And it's been great to work, of course, with my colleagues on that. So I'd like to talk a little bit about the team. My name is Matthew Shervinack. I started the Sunwater Institute back in 2017. I was an entrepreneur before doing this in the data area, so I have a lot of data experience. Annie Haruchinyan, she's here with us. She's a director of research at the Sunwater Institute, and she has wonderful experience not only in the patent area, but she also drives other areas of our work in group decision-making, where she's done work with MIT and Yale University, managing some of our projects there related to legislative bundling, also data-driven projects that are of very high quality and high level. And she, of course, has a PhD in economics. Next, I'd like to mention Mark Shankerman, who's a professor at LSE. He's well-known in the patent area and a well-known economist focused on innovation and has had a long career and with a lot of really innovative ideas and innovative approaches to understanding innovation, understanding the intellectual property system. Will Matcham is with us as well. Both of them have come from the UK over the last couple of days, so they've adjusted to the time. Will has worked with Mark for many years, also doing the same kind of very exciting, innovative work, also a PhD in economics. And last who's not here today is Nishant. He helped us on the project. Good guy, did a lot of the data work, so we thank him. Great, so with that, I will hand it over to Annie, and she'll walk us through the executive summary, and then we'll go into the moderated discussion. So please, Annie.
Good morning, everyone. I want to thank C4IP for hosting this event and giving us opportunity to talk about our work. Yeah, economists do great things, but they hardly get an opportunity to convey their messages to policymakers and lawmakers, so we really appreciate this. I'm going to provide a brief overview of the report, and we expect go into detail on some of its parts during the panel discussion and the Q&A session, also depending on which parts you all will be particularly interested in. But first of all, and most importantly, we need to get on the same page what we mean by bad patents, good patents, and what we mean by patent quality. These are very loaded terms. They mean different things to different people. But this report is very clear about the definition of the concept of quality it's using. So this report evaluates patent quality in the US by evaluating the effectiveness of the patent examination of the US Patent Office, the USPTO. Thereby, it's using the same concept of patent quality as it is used and adopted by the USPTO itself. So USPTO considers a quality patent to be one that's correctly issued in compliance with all the requirements of the Title 35 of the US law. So the good patent satisfies the criteria for patent subject matter eligibility, it's novel, it's non-obvious, and it's clearly and sufficiently claimed and described. So if a patent that has been issued by the USPTO, if that patent doesn't satisfy at least one of those criteria, one of these statutes, then it's a bad patent. It shouldn't have been issued in the first place. The USPTO has made an error, and that's what we call type 1 error. But we go one step further and ask, how about all those patent applications that satisfy all those statutory requirements, but they have not been issued patent by the USPTO? So yes, USPTO has made an error there as well, and that's what we call type 2 error. So to be clear, the analysis presented in our report take the statutory standards of patentability, the US law, or in other words, the patentability threshold, as given. And then look all those patents that do not meet those standards. So that's the type 1 error, the bad patents. And then also look all those patent applications that meet or exceed those standards but have not been granted a patent. So this is the type 2 error. So now that it's clear what is type 1 error and type 2 error, let's the question is, how do we estimate this? It's actually not very easy, not very straightforward, but it's not impossible. In fact, our report considers 3 different methodologies of doing just that. So the first methodology analyzes large data set of patent applications that have been filed in a certain period of time, and then tracks whether they have been accepted, granted a patent, or rejected by the USPTO. And then using economic modeling, machine learning, and statistical analysis, evaluates whether they have been correctly accepted or whether they have been correctly rejected. So this is actually work that's done by Mark and Will, who are here today with us. So we expect to talk more about this methodology with them. The second methodology, instead of looking every single patent application that has been filed, randomly picks a subset of patent applications just to make sure they are representative, let's say across technology centers, and then reviews the office actions prepared by patent examiners at the USPTO to see whether they have been correctly accepted or correctly rejected. This is an evaluation that's actually done by the USPTO itself, by its Office of Patent Quality Assurance, DOPQA, and the results of that review are then published in aggregate form in its quality metrics. So what we have done, we analyzed that quality metrics, and based on that data, which is publicly available, we provided estimates for type 1 and type 2 errors. The third methodology looks at patent applications that have been submitted to multiple patent offices. So if the same patent application has been accepted in one office but rejected in another office, that's a variation that can be exploited to learn something from it. This can be because the patentability standards, the law is different across countries. Something that's patentable in one country might not be patentable in another country, and that's perfectly fine. But what if we are able, using these econometrics methods, we are able to control for those differences in the patentability standards, but we continue to see differences in the decision outcomes. We continue to see some patent application accepted somewhere and rejected elsewhere. And that might be because one of the offices has made a mistake. And that's how type 1 errors can be evaluated. And the good thing about this, once you evaluate type 1 errors for each office, you can actually compare them with each other. And that's where we can compare USPTO with the performance of USPTO with other offices. So the next slide presents the findings. But before I talk about the findings, I want to share with you what I found the most fascinating when I was working on this project and bringing all these pieces together. Even though these are 3 different methodologies, even though they use different data sets, they cover different time periods, they all arrive at more or less same findings, they all arrive on similar conclusions. That's why when I present the findings in the next slide, I'm going to feel quite confident about them because they are robust. So let's see the findings. So the first finding is about the type 1 errors and that it is in the single digits. So one methodology finds it to be around 7%, one methodology finds it to be around 8%, the other methodology finds it to be around 5%. What we can confidently say, these type 1 errors are less than 9%. So this is the bad patents, right, the type 1 error. These results might be surprising to some, since we usually hear about different magnitudes of prevalence of bad patents. I personally encountered lots of media articles, on law review articles, giving us different numbers. We'll talk about where these other numbers are coming from later in the discussion section related to PTAB and court invalidation rates. But in order to understand whether these single digits error rates of type 1 error rates are low or high, we actually need to, it's useful to benchmarking them against the same error rates of other offices. And that's where our second finding comes and says that actually USPTO is not doing any worse than any other global patent office in the world. In fact, according to the study we present in the report, the type 1 error of the USPTO is much lower than that of EPO, JPO, and KIPO. So the next question is, okay, it seems like for type 1 error we don't need to worry about. So how about the type 2 errors? So the type 2 errors come up to be, according to all three methodologies, they come to be in double digits and way higher than type 1 errors, which means that the USPTO rejects more potential good applications than it grants bad patents. This third finding, actually I find not only, I find the first finding is as insightful as the first two findings, but I find it also a bit alarming, taken into account the current policy debates, because as Matt has also mentioned, the current public discourse focuses intently and almost myopically on type 1 errors, on bad patents. Nobody really cares to talk about type 2 errors, to talk about those great patent applications that meet and exceed the patentability standards, but they have never been given a chance to be a patent. So one important thing to understand why it's alarming to have such an approach is because both of these errors, both type 1 and type 2 error, they come with their own associated socioeconomic costs. Both of them are costly for the economy and for the society. And both of these errors exist in equilibrium. So if as a policymaker, my goal is to minimize type 1 error as much as possible, I am inevitably most likely going to increase the type 2 error. So while I'm minimizing the costs associated with type 1 error, I'm increasing the costs associated. On the other hand, I'm increasing the costs associated with type 2 error. So as a result, the net effect of my policymaking might be negative. Our first recommendation is that we propose to frame the patent quality dialogue in terms of optimal balance between those two types of errors. We'll talk more about these costs associated with type 1 and type 2 errors and why it's so important to have an optimal balance approach to policymaking and look at the patent system reforms as a whole, not just focusing on one part of it. So we did our best to get these results to you, and we need better data to do more. USPTO actually provides quite good data for analysis. Probably, it might be even the best among all patent offices, but it can be better. There is room for improvement. For example, regarding USPTO's quality metrics data, I mentioned in the report that more granular data should be shared publicly, which will allow researchers to provide more detailed information on the error rates. And some of this data already exists. It just needs to be shared. For example, in the case of quality metrics, I mean like claim level data and broken down by technology centers, I'm quite sure this data already exists. So we just need to ask USPTO to share it. And ultimately, in order to overcome the widespread misperceptions regarding patent quality, there is need for more systematic and regular assessment of patent quality using methodology and data that are accepted by a wide range of experts. How about wide range of experts from different camps come together, agree on a methodology, and they urge the USPTO provide data sets to use in those in this methodology, and then evaluate patent quality, let's say, every year. And ideally, we would like such analysis to be conducted not only in the US, but also in other countries to gain a more comparative perspective. So we economists have ideas how to do all of this moving forward, and we'll be very happy to share if there is an interest. Thank you for your attention, and I look forward to discussing more.
Excellent. Thank you, Annie. So Annie, maybe we'll keep on you for a second. Let's just start things off. Let's talk about invalidation rates. So people use invalidation rates. They say, oh, invalidation rates are 30% or 40% or 60% or whatever they are when they go into the courts or PTAB. Why can't we just say, oh, all the patents should be rejected at a 50% rate? 50% of all claims are bad. I mean, that's what some people do. Yeah. So why is that wrong?
It's important to understand where these numbers come from. So they come from courtrooms, they come from PTAB trials. For illustrative purposes, let's focus on PTAB for a moment. So a subset of patents that have been granted by the USP2 get challenged at PTAB. That subset is not randomly picked and is not supposed to be randomly picked. And it's not a representative sample of the overall pool of patents. Actually, we do some data analysis to show that it's not a representative sample across multiple characteristics. So if it's not a representative sample, so whatever is true about that small subset cannot be generalized for the whole population of patents. Similarly, if I want to make a judgment about the US population, I cannot just look women or only teenagers and say, because teenagers do this, the whole country does this. I need to carefully pick a representative sample of all ages, of all genders, proportionally representative. So PTAB doesn't do that, the challenges at PTAB, and it doesn't suppose even to do that. So it's not a representative sample, so characteristics specific to them cannot be generalized. But there is lots of selection going on there, which patents gets challenged at PTAB. But there is another layer of selection that happens, which patents ultimately go to the trial. So some of them get challenged, but only a portion of them get into the trial. And there is another selection happening there. And according to theories of litigation and settlement, only very uncertain disputes go to the trial. Because if you have a dispute, and I'm very sure I'm gonna win, you are sure you're gonna lose, or other way around, we don't need to go to trial, we just sit and settle here right now. But if we are very uncertain about it, we go to trial to find out what's going to happen. And it becomes like tossing a coin. That's where the 50-50%, that's where the 50% rates come from. So again, the theories of the literature in law and economics have predicted this 50% rate long time ago, and there is lots of empirical work, some of which also done by Mark, has validated those theories, and also like why it can be like not exactly 50%, but let's say plus minus 10%, 40 to 60%. There are also theories about that. So this is where these numbers are coming from, and they have nothing to do with patent quality.
Excellent. So maybe the next thing we can talk about, since you did do some kind of a study on all the patents. So maybe, Mark, can you take us through, how did you do that? What's the methodology there?
I'd be happy to. So what Will, excuse me, what Will Matcham and I have done over the last 5 or 6 years is to develop a methodology that's formal in the sense that it's actually modeling. That by itself isn't virtuous, but it's then taken to the data and allows us to study the whole process of patent screening within the USPTO. And this modeling is important for several reasons. First of all, let me just describe very briefly what is this formal economic and then statistical model of patent prosecution or patent screening incorporate? I mean, why should anybody believe that it's a reasonable description of what's going on? Well, let me just tell you what's incorporated. We've studied in detail the main institutional characteristics, of course, of the USPTO and tried to the extent possible in any stylized model to incorporate them formally into the model. So here's just a subset of those things. First, we have both the applicant and the examiner facing various incentives. In the case of examiners, you'll all know that they have credits for various decisions at various stages, rejecting, not rejecting, asking for revisions, and so on. And the applicant faces various incentives or costs, including but not limited to fees for various stages of prosecution. But it's not just fees. They also have to pay lawyers to draft patents, to amend patents. So through the whole patent prosecution process, both parties to this negotiation, if you wish, are facing incentives and costs. That's all incorporated into this model in detail. Secondly, because it's a public agency, one might think that examiners have what economists like to call intrinsic motivation, meaning they want to do the right thing, that is to align their behavior with the objectives of the patent office. Okay, so only to grant when they should, and only to reject when they should. Now, not all examiners may be intrinsically motivated. There's evidence in other contexts, by the way, outside of other public agencies that this may exist. So we actually incorporate examiner intrinsic motivation into the model and estimate it. So we actually have, we can say something quantitative about whether this is important. Turns out it is important in the patent office, which has other implications, like how do you hire people? How do you sustain intrinsic motivation? The third feature is, as I mentioned before, the fees for applicants at every stage, and the legal fees for doing each thing at each prosecution stage, and all of that's incorporated, okay, as real numbers. And then, of course, we have this model incorporates the narrowing of claims, and we focus on independent claims, patent claims rather than the patent, because the patent is a bundle of claims, and the decisions by examiners effectively are made on the claim basis. That's how the model works. Excuse me. And so at each round, an examiner asks for some narrowing of the claims because he thinks that it's too broad. And that then is done, and we, again, are able to estimate how much narrowing takes place, okay? Which is another way of thinking about, during the patent prosecution process, how much fat is being cut away by the process. You may get a patent, but you might not get a patent that you asked for. And then finally, and very importantly, applicants and examiners in this formal model, it's quite complicated, behave rationally in their interests, in their own interests, okay? Given the constraints of the system and given the various incentives and fees they face, okay? So everybody's behaving rationally. This model generates predictions, what we call equilibrium predictions, okay? Outcomes. How long do things take? How many rounds do they go through? What's the percentage of claims that are granted, not granted, and so on, okay? So these are all outcomes of this model. And then what we do is to match those outcomes to the observed outcomes. And the parameters of the model, the characteristics of the model, are chosen such that those two things will be close. Okay, so it really is disciplined by the data in an integral, intrinsic way. It's very important. Now, I want to just mention one other thing. I'm happy to take questions after the fact, of course, during the Q&A on details, but this is very important. You might say, why do we need all of this? Why don't we just do something like look at OPQA, the Office of Patent Quality Assurance, which is one of the three methodologies used in the report. Each methodology has its own advantages, and so triangulating, as the report does, with these three very different methodologies and different data, I think is a very great strength of the report. But the one feature that the formal modeling allows us to do that none of the others does is that it allows you, because you have a formal description of what's happening, you can do what economists call counterfactual simulations, which is basically asking the question, what happens if we reform the system in some way? What happens if we change an institutional feature, change the credits to examiners, change the fees to applicants, change the number or limit the number of rounds you can go, like limiting the number of RCEs, the requests for continued examination, okay? You can't do that with any other methodology. You need a formal structure to do this. And we do this. And just to give you a flavor for, and so since all of us are interested in reform to improve things, this is crucial. Okay? It's the only methodology that allows you to actually, now, like any model, it's imperfect, but not perfect, but allows you to make quantitative statements about how these various outcomes change, including type 1 and type 2 error, but also other things. Okay? And I'll just give you one example from Will's and my current work. One reform, in fact, the reform in the USPTO that stands out particularly efficacious in improving things is limiting the negotiations to 2 rounds, okay? Rather than being able to run on for as long as you want, as long as you pay the RCE fees, okay? Now, there may be legal and other constraints that one wants to bring to that discussion. That's fine, we can have that discussion. But this is an example. And by the way, I would mention that it's interesting because the EPO, the European Patent Office, limits it effectively to 2 rounds. So in thinking about reform to the USPTO and any other system, this comparative aspect, I think, is very important. And if we can identify with these formal models the consequences or likely quantitative consequences of different institutional design reforms, then we're really going somewhere. And that's what I think this methodology can allow.
We talk about bad patents, but to me, and I think we're all in agreement here, where we need to look at the patent system from a claim level. Looking at patent by patent doesn't make any sense, because you can have a patent with 100 claims in it. You have one bad claim. Is it now a bad patent? Has 99, or is it an amazing patent, right? With 99% valid claims and 1% invalid claims, is that now a bad patent? Or if it has one valid claim and 99 invalid claims, right? Is that a good patent because it had one good claim, or is it a bad patent because it had 99 invalid claims? So people can say good or bad patent and not really have any meaning. What we have to go down deeper and look at a claim basis, and that's really what we tried to do in this project, is look by claim, because that gives you real information about the quality of the patent system. So maybe, Will, could you follow up a little bit with, on what Mark was saying? Can you get more into the detail? Tell us more, how do you measure this kind of patentability threshold, things like that?
The first question to really think about is how do we use data to determine whether claims are valid or not in our paper, in our work? So Annie was mentioning about these 4 criteria that have to be met to ensure that a claim is valid. I'm going to focus the discussion mostly on novelty and obviousness. These are the most prevalent, the most common grounds that are discussed, and there's actually a big overlap between the other grounds when they occur and novelty and obvious as well. So it's good to focus the discussion on those, and David actually mentioned in the beginning this idea of an inventive step. Novelty and obvious, people talk about this inventive step. So what does that really mean? That's about being far enough away from what exists. And so you need to be sufficiently far enough away to be considered non-obvious, right? So when I'm talking about this notion of being far away, that's kind of already talking about distance. Being far away is about being, having a large distance from what already exists. So people typically think of data as numbers in spreadsheets, but nowadays, a patent is text. So the data we use is the patent text, and we use modern AI methods, this kind of machine learning, which is exploding these days in its usefulness, to calculate distance between texts. And that's really useful for us to have to assess whether claims are valid, because if you can get a good measure of distance between claims, then you just have to check whether that distance is large enough. And that's really the idea of making a sufficient inventive step. So that's kind of how we think about validity, or how we use data to assess validity in our work. Perhaps then I could talk about why it's so important to have this kind of data. The reason why is because we're talking about whether examiners make errors. So type 1 error, they grant a patent, and it has claims that don't have large enough inventive step, small distance. Well, if you want to know if they made an error or not, you need to know what decision should have been made. So an error is you're saying that they shouldn't have granted this claim. We need to know should they or shouldn't they to say if it's an error. So that's why you need this kind of benchmark of the distance versus the standard. So this is why it's really important to have the underlying kind of benchmark data to assess whether errors are made or not. That's why the distance data is so crucial for us. So we mentioned other kind of examples of assessing errors, such as the OPQA, but it's kind of important to note, as was mentioned, that's done by the USPTO, that's internal. And as Mark was mentioning, just to repeat, when we want to think about reform, so if you imagine we want to talk about, should we change the standard? This is something that's not been said yet. Is the standard correct? Well, we can think about that with our work, but you need to have this underlying distance to assess what will happen to type 1 and type 2 errors if you change the standard. So that's another reason why having our kind of text-based distance data is important. I guess one thing I should mention a little bit more on, because I've been a little bit vague on it, is this distance and this AI measures, because everyone seems to be talking about AI these days, and I think it's kind of hard to get a good grip on it. So we implement these modern AI and computer science methods. I'm not going to bore people with the details, don't worry. But really what these algorithms are doing is exactly right for our context, because they're looking for text similarity. How similar is are 2 bits of text? So we can take these methods and adapt them for the patent case. So many of you will be familiar with something like ChatGPT. Everyone keeps talking about it these days. But that is trained on something like Wikipedia or the internet, whatever. But when we train our own algorithm, we use patent text because, as you may well know, patent texts look very different to fiction books and whatever. They're typically very impenetrable to understand and deliberately hard to understand by the attorneys. So that's what we're doing. We're using something in the same spirit as these kind of ChatGPT methods, where they're learning the meaning of words in their context. And once you know the meaning of words, you can work out whether 2 different paragraphs are similar or not, because you understand words in their context. That's kind of a very high level of how we use these AI methods. And just one more thing on that, the previous methods that have tried to measure distances between texts would look if they had the same words in common. And we wanted to build on that because you can see some limitations in that. If you talk about one patent claim has a bread heating machine and the other's a toaster, well, they don't use the same words, but they're exactly the same thing. Whereas the kind of modern methods will understand toaster's about putting in bread, the other one mentions bread, so actually they're close. So that's why it's really important to improve and use these modern methods to get a good measure of distance.
The power of it is that you can look at every single claim, right, in the entire patent pool. You don't have to just look at a few and try to generalize. You can see the entire pool, right, and you can apply that logic to any set of patents. It's just, it's an amazing work. And obviously, it's a model, right? It's a model. It's got its inherent limitations as a model. But the power, as you mentioned, one of the key powers is that it's totally comprehensive. It can look at every single claim. Whereas we can't retest every single patent to see if the quality of the patent is, we can't retest every claim and run it through another process, another PTO, to see if they did a good job. But that leads kind of to my next question. Maybe this is for Annie. The USPTO does do a random sample, right? If we zoom out, we've talked about the entire universe of claims. Now the PTO itself does take maybe a random sample, maybe you can explain. And what can we learn from that USPTO quality metrics data? What do they do and what can we learn?
Yeah, we actually learned a lot from USPTO's quality, OPQS quality metrics, and I think they are doing great work. And I'm surprised these numbers are not well cited by media articles and other. I'm just surprised that there is not much talk and dialogue about what's coming from there, because we can learn a lot about it. And one of the things we can learn that I didn't mention earlier is that you can estimate type 1 and type 2 errors by each statute and see how patent examiners do, how these error rates compare to each other, like section 101 versus section 112, let's say. And the sample is representative, that's what they claim, and we kind of did some data analysis to check to make sure that it's representative, at least across technology centers, so that's representative. So they are doing a great job, but what as a researcher, what I'm not happy about is that they should share more of their data, the work they are doing. They should share with us publicly more of their data. We would like to have them share the claim level data, which would allow us to come up with more accurate estimates of type 2 errors. Type 1 error estimates we have are very accurate based on the data they provided. But if they provide claim level data, that would allow us to have more accurate estimations for type 2 errors. And moreover, they can also share data by technology centers, so that way we can compare type 1 and type 2 errors across technology centers, which is also very insightful in terms of patent quality by technology centers. That's actually something Mark and Will are doing, but we would love also the OPQA share this data. Yes, we learned a lot, but we can learn more if more data is shared.
Let's move off the concept of data for a minute and talk about costs. So, Mark, you've thought about costs of type 1, type 2 error somewhat. I think we have better, better ideas about how to quantify type 1 error than we do type 2, and you and I might approach those things differently. Can you talk through your perspective on the costs of type 1 and type 2 error?
Yes, I think, thank you. The basic finding that comes out, certainly from our work, my work with Will, is that type 1 errors, that is false granting, is much less common than type 2 errors, which is, as it were, false rejections, incorrect rejections, okay? Which, by the way, are hidden. But those are the ones you don't see. People can see that a swing might have been granted and bang on about the silliness of granting to a swing. I use that, of course, not apocryphally. It's an example, a real example. But what about the type 2 errors? Those are hidden. Well, maybe they don't have any costs. Let's see. Will and I, in our work so far, have actually done some preliminary calculation of these costs. It's not an easy task, and it's more difficult to do type 2 than type 1, but let me describe why, okay? What are the costs? I'm thinking here of economic costs. Okay? What are the economic costs that type 1 error false grants impose? Impose on who? On us, on society as a whole. Well, there are basically two types. Okay? One is sort of obvious, the other is probably less obvious. The first one is that when you're granting a patent, or patent rights, patent protection, temporary monopoly rights, if you want to call it that, though I don't like the term, where you shouldn't have done, the owner of those rights will raise the price of that good. Okay? They're able to do that and extract some royalties from the patent. Okay? Those higher prices are the cost, or are the source of the costs, to be more precise. Okay? They wouldn't have occurred if you had not given wrongly this patent. Okay? Now, higher prices, not quite right for an economist, because part of the price hike will go from consumers to producers, and so that was what we call distributional. It's kind of who gets the money. But there are associated costs, which I won't go into unless you want me to, called deadweight loss. There basically are some costs that are associated, and the basic reason for that is when the higher prices are imposed, consumption goes down. People use this thing less. Okay, and that's really where the costs arise. Okay, so that's the first cost, higher prices, if you want. But the second cost, and that was the duration of the patent, unless there are substitutes that come on board that compete. The second, though, is perhaps a little bit more subtle, which is that when you have, as I think it was Richard Posner, actually, I think who first made this argument many years ago, was when you have a monopoly right, wherever it comes from, you're willing to spend money to protect it. How much money? Well, up to the amount that you're earning from the right. Now, what's the context here? The context here is defending your patent. Even though you shouldn't have had the patent, you have it, and it's generating money for you. So therefore, the patentee will incur litigation costs, and so will the other side. So there are, let's say, symmetric litigation costs, which would not have been incurred by society if you hadn't made this mistake in the first place. Right? So that's socially wasteful. Apologies to any lawyers. Okay? That's socially wasteful for society. And both of these can be computed. Okay? The second of those is more difficult, but we actually do some preliminary calculations of that sort. Okay? And we're continuing this work until we are completely satisfied with the credibility and robustness of the findings. Now, what about type 2 errors? So those are the two. What are the two sources? Now, what about type 2 errors? Well, type 2 errors, or not granting what you should do, basically what that does is that if inventors understand that there's a probability of type 2 errors, that they have a legitimate claim, but it's not going to be granted, if there's a probability of that, they will take that into account in deciding whether to develop their idea, innovate, if you want, incur the R&D expenses to do that. So what type 2 errors really do is that they impose a hidden dilution of innovation incentives. okay? And, and if type 2 error is frequent, and our numbers are suggesting, something on the order of 20% or more, 25% error rates on type 2 error rates. That's high. And so that's going to lead to, effectively, less innovation. Now, can you measure the less innovation? Not really, because you don't see the innovation because it didn't happen. Which is, by the way, why it's ignored in the public debate, because it's not visible. But it's no less real for not being visible, okay? Now, we have a way, but it does require assumptions, okay? It's becoming, these assumptions, by the way, are not required for the basic model I described. But if you want to calculate the social costs of type 2 error, you have to make additional assumptions, and it's quite complicated. I won't go into it unless you want me to do more on that. But effectively, it's trying to compute the counterfactual, what inventions would have been made had the inventors known that type 2 error was not going to be present. Okay, and we have a formal way of doing this. That's going to depend on a variety of things, okay? And so that, but you can measure it. So the calculation of type 2 error costs, social costs or economic costs, is almost inherently more speculative. It's more difficult than type 1, but it doesn't mean it can't be done, and we're doing it. But I think one wants to be a little more careful about making claims that are, you want to check robustness. That's very important. Okay, so that's essentially it. I just want to emphasize one last point on this, which is the triangulation of these three different approaches in the Sunwater report to measuring type 1, type 2 error pretty clearly demonstrate, I think, and to me credibly demonstrate, that type 2 error is more common, actually much more common. But if you want to assess whether type 1 error, type 2 error is more serious, you have to attach to that the social costs, okay? And that's why measuring the costs as best we can is so crucial, because you can't, and shouldn't anyway, base policy judgments just on the relative frequency of the errors, okay? And that's why we're trying to actually put meat on it and provide real evidence.
We call it also the moral cost, right? If you have inventors who have gone to all the trouble to invent things and they don't get a property right around that, to me, that goes beyond economic cost into, I guess we call it a moral harm. Nobody likes me to use that term, but to me, it's a very serious thing for as an entrepreneur. And like you said, if you're not, if you discount the probability of being able to get that patent or enforce it, is the other part. We're not talking about enforcement here, but on the one side you might not get the claim. On the other side, even if you get the claim, maybe it's not enforced either here or abroad. That also is going to come into your calculation about whether you pursue the invention to commercialize it. So enforcement, of course, plays a major role in that calculation for the entrepreneur as well. So maybe I'll just have one last question for the panel. We'll open it up. Maybe just go down the line. What data could we get that we want? What analysis should be done to take the next step for patent quality? And maybe we start with you.
Yeah, I've already mentioned a little bit about data from USPTO. It's actually very, very good. Again, maybe one of the best compared to other offices, but there is room for improvement. And I'm very curious about cross-country comparisons, and it would be nice to get data also from other patent offices and analyze it. Yeah, again, we presented the work that has already done it, but we would like to do more of it.
Okay, I just want to emphasize, first of all, the importance, of the reform question. I want to come back to that just very briefly, the importance of the reform question. Because at the end of the day, what we want to understand is, are there changes to the USPTO, prosecution structure, incentives, whatever, or other, by the way, because US inventors also care about the JPO, the EPO, the European Patent Office. So we ought to be also, possibly even as a country, proactively trying to make those institutions more effective, because They matter for our inventors and our competitiveness too, speaking as an American. But anyway, in order to do that, what we really need is institutional comparison. And will talk, I think, a little bit about that. So we need studies that do something like what we were trying to do, have done for the USPTO for other institutions, and then ask, something about what works better and what is the source of the improvement. If the EPO is better or worse, is it because of this feature that differs from the USPTO or that one? And our methodology can actually do this in principle. Okay. Now, what I want to focus on is PTAB. Because what we haven't said anything about is the second layer of screening, which is PTAB. And Accords, of course, but let's think about PTAB. And the European Patent Office has something very, very similar, not identical, but very similar, called the opposition procedure. Okay? Now, the JPO, I don't know. We're actually looking at that. So what is it about PTAB? Well, again, as Annie said, the invalidation rates don't matter. They're just not informative. Full stop. Because of the selection, the non-representativeness. It's not, so we just shouldn't use them. But as someone once said, the dog barks, but the caravan keeps moving. So I'm sure people will still use them, but
they're gonna continue.
But they shouldn't. They shouldn't. But anyway, the PTAB, what we really need to understand is this, and we don't know because there's no evidence. Okay, we're actually doing a study of PTAB right now, and what you want to know are three things. One, who gets challenged in PTAB? Okay. Two, what happens in PTAB? Does it get so-called instituted? Does it get screen rejected? Or does it move on to adjudication? And if it moves on, or does it settle? And if it moves on to adjudication, what happens? Okay. Now, again, so that's all the selection issues. And in order to say something about whether PTAB is effective or not effective, or its European counterpart, what you need is to relate it to the distance measure again that Will was talking about. Because what does it mean? Who should get challenged? Well, who should get challenged are patents claims that are below the threshold that shouldn't have been granted. But is that true? We know it is true to some extent from our existing work in Sunwater. But there's more to be done. And when it gets into PTAB, which ones go on to adjudication? Is it the ones that should go, that is the type 1 errors, or not? Until we know that, we can't speak well or poorly, okay, of PTAB, okay? We can't make any normative judgments about it being the graveyard of patents, okay? Because maybe they should have died if they shouldn't have been granted. Okay, so we just don't know. We're going to know, I hope, within 6 months or 8 months, and I hope that we can contribute to the congressional discussions on that. And so that's what I think, I think it's really looking at the second layer of screening, because then, once you have that, together with what's happened in the examiner level, maybe PTAB effectively takes care of type 1 errors, or maybe it doesn't. We just don't know. And what about type 2 errors? PTAB considers, and the opposition procedure in Europe, not just challenges to granted claims, but appeals by patentees of rejected claims. That's type 2 error. Which ones are appealed? Are those the ones that are type 2 errors, that they shouldn't have been rejected? Or is it just self-serving that they appeal these claims? And again, what happens to these appeals when they get into PTAB? That, I think, is a major lacuna, missing piece of information, but we know that it can be answered, and we're going to try to answer it.
Yeah, some of that's a little challenging because, especially the type 2, for a lot of entrepreneurs, may not have the money or the time or the energy to do that appeal. So, that's something you got to think through and adjust for. Will?
Yeah, just briefly. As been mentioned twice, but I'm going to say it a third time to make sure it's clear. The current work on global comparisons kind of stops just at comparing the amount of errors in different offices. And that is not enough, in my opinion, and in our opinion, for not just because US inventors file in these other offices, but because we want to improve the current US system as much as we can. And there's features of all of these different offices in Japan, in Europe, which are different. For example, in Europe, they have 3 examiners. In the US, we just have 1, typically, looking at the application primarily. So should we have 3 examiners? That's going to be costly. Or should we just have 1? What are the effects of having 3 versus 1? We need to build models. We need to continue our work on the European system to understand those and to answer those kind of questions. And that's a big undertaking because all the offices are different, and we need to retrain our algorithms on these European patterns, or even in Japanese, that's going to be even more difficult if they're written in Japanese. So there's a lot of work there, but it could be extremely rewarding to have models of all of these different offices, Korea, Japan, EPO, USPTO, and to understand all of their features, and then we can think about, should some of those features of the European one be used in the US or not? And then we can really understand not just the US as it currently functions, but the whole possibility of what a patent system can look like.
With that, I'm going to use a little bit of our prerogative to first ask the 2 former PTO directors if they have any questions regarding the study, and of course, Judge Michel from the judiciary. So, gentlemen?
I'd certainly love to hear from Judge Michel, but just a quick one from me to end. You mentioned that you were able to look at tech sectors, as a tech sector basis to some extent. Could you just talk briefly about the level of variation you saw, if any, across X sectors?
Again, we were not able to do it in the case of data coming from the USPTO, PQA, because it was not shared, but we looked at that using the methodology that Mark and Will developed, and yeah, the results are right in front of me, that for across all technology centers, type error is always higher than type 1 error. So there's no variation in that. That's consistent across all technology centers. However, in some technology centers, type 2 errors are way higher than type 1 errors than in others, and especially the case with computer networks, communication, cryptography, computer architecture, software, information security. We did have some explanation on that, why their type 2 errors might be so much higher compared to type 1 errors in those specific technology centers. Would you like to elaborate on that?
I don't think we know. I mean, the methodology certainly can do everything I described by technology center. By the way, you can also do it by entity size, like small firms versus large firms, something we haven't talked about, which is going to be of interest. But yeah, you can do it by technology center. They do vary, as Andy pointed out. The baseline message about type 1 error being less frequent than type 2 goes through. But computing the social costs associated with those by tech center can be done at a stretch, with more assumptions. We've begun that work. But we don't know much about it yet.
What an impressive presentation of a monumental work. It's just kind of astonishing to think of what the next steps could be, many of which have been outlined by the presenters. I don't want to add to the list of further levels of analysis that might fruitfully be pursued, but I have to go back to what Dave pointed out in his opening remarks, that a lot of the legal standards are not very clear, and so predictability is low, and so settlements that are efficient that could happen if the law were clear don't happen, and then everybody spends a lot of money and time, and it's a sort of a roll of the dice what the final outcome was going to be. So one of the things that would be fascinating for me as a former judge of the patent court to see explored was the whether particular clarifications in defining the distance and non-obvious distance. This could be made in the law, in the statute, would produce good results. If you see what I mean. Because it seemed to be the reality that judges have no understanding at all of what the downstream consequences are going to be of verbal tests that they inject into the law and kind of tease out further meaning of what 101 means, 102, 103, 112. And so I think there's a potential, my hypothesis at least, is that there's an end of great improvement by clarifying local law so the statute is clear and not subject to variations of interpretation by different judges or different examiners or different board members. So that's a whole other level of analysis that I think might be extremely beneficial.
So there are these statutory requirements, and then USPTO follows those and issues patents that meet those requirements. And then the next day, there is a case law coming, and the patent, which was high quality at the time of issuance, is no longer considered low quality. And that's not the fault of USPTO. USPTO did the right thing issuing the patent at the time. Now law changed, and patent became bad patent. And USPTO shouldn't be blamed for that.
Just coming back to your comment, if I could, just for one second, we have, it's a great comment. I think that it's how to do it. I don't know. I'm going to think about it, but it's definitely important to actually embed that upstream in sort of the assessment of judges and others as guidelines, somehow quantitative. But I just wanted to say one thing that one can do, we haven't done, but one can do, which doesn't go as far as you're suggesting, but could potentially illuminate the importance or unimportance of this uncertainty about what things mean, is to look at specific cases that arguably clarified something, yeah, and look at sort of the error rates and so on, measure these error rates before and after that, as a way of a first cut at does clarification of a reduction of uncertainty in the statutory thresholds help. But it doesn't go as far as you want, which I think is very important, which is actually trying to formalize that somehow as guidance for practitioners.
So I apologize. We only have time for one last question. I'm going to turn to Andre.
To Judge Michel's point and Mark's remarks, we did just that with Section 101 and the change in the guidelines we gave from the PTO in 2019. So once we promulgated the 2019 101 examination guidelines, we looked at rejection rates and predictability pre and post that change in the guidelines for examination. And in that particular example, we showed that the rejection rates went down by over 20%, and the consistency between examiners and examination outcomes increased by over 40% in light of the guidelines. So it's definitely doable. You have to just pick the marker in time based on some decision, whether it's from the court or the office, and you run the statistical analysis pre and post. It's definitely doable. And I think, to Judge Michel's point, I think it's a worthwhile exercise as an additional study if we choose to do it. Just a couple of comments. I am particularly, so I'm not surprised that type 1 is lower than type 2 in the United States. I am surprised by the magnitude. It's from at least 2 times as high in type 2 to as much as 5 times according to your report. And really the social costs are quite dramatic. I don't think you've measured them, and Mark talked about some of this. But think about the correction mechanisms. There are significantly more correction mechanisms for type 1 errors than for type 2 errors, right? So, the public is not going to take the PTO to court or whatever to grant the patent where it rejected it. Very few applicants actually continue the appeal process if they have a rejection. Whereas if you have a patent that's improperly granted, the whole public has a range of correction mechanisms, ranging from the very inexpensive and ex parte re-examinations to post-grant proceedings, such as PGR and IPR, and ultimately in district court, either when challenged with an infringement action or with a declaratory judgment action. So there's so many correction mechanisms, and you have an error rate in type 1 in the single digits. And combine that with the increased correction mechanisms. Again, I ask, for those who say that we have a pandemic of bad patents, where is your evidence for that? And the last point that I want, at least for myself, to conclude in my mind is how much better the PTO is, the US PTO is, compared to the other offices. So yay PTO. It doesn't, the negative commentary about the work the examiners do is not well placed. Obviously, patent examination is not a perfect science. You're dealing with complex issues of technology, law, and the English language. But they do a remarkable job, and according to your study, a significantly better job than most of the offices around the world, including the EPO. So I do think it's important to realize that the work the examiners do on a day-to-day basis, together with a system that is in place, despite all the flaws, is actually pretty darn good.
So thank you, Andre, and thank you all for being here today, but a special thanks to the Sunwater Institute and their team for an amazing report, and we really enjoyed hearing more from you today about today's briefing. Those of you who have questions, feel free to follow up with C4IP directly. We'll, of course, be happy to try to get those questions answered. Lot to unpack here, but I think this report is going to be very helpful in resetting the narrative. So I want to thank Matthew and the entire team for taking time to be with us today. Thank you all again, and this concludes today's program, so thank you very much.